Good evening, everyone. As you can see, we have a guest tonight. We will wait a few minutes, seconds, and we'll get started with our Facebook Live this week. And I have, of course, Attorney Ravani. If you've not met her, please check out her bio and also the Meet Our Team series, which is on YouTube. And you can learn more about Attorney Ravani and her practice back home and her experiences here with our office. All right, so today we're going to talk about several things, primarily something that's called a Writ of Mandamus. And before we get into this topic, I do want to go ahead and share our traditional good news and updates with you all. So we're going to go ahead and I'll have Attorney Roshni go ahead and give one of her good news for today.
Okay, thank you, Naya, for the introduction. Good evening, everybody, and welcome to our Thursday's Facebook Live. So this week I went for an adjustment of status interview for a client. He is married to a U.S. citizen. After waiting for 2 hours for the interview, his petition was approved, and he got a 10-year green card instead of 2 years. Because by the time we went to the interview, his marriage has already passed the 2 years. So we had a successful adjustment of status petition. The client's happy, the wife's happy, and yeah, we are happy. So all our hard work paid off.
So we've been seeing this at a lot of USCIS offices where unfortunately they're understaffed due to COVID. And sometimes you're waiting 2 hours. And for many clients this week, we actually had interviews canceled. 4 people were scheduled for interviews this week, only 2 attended. So that's something that they've been trying to do and hopefully reschedule. So if you found yourself in this situation, you're not the only one. And good job, Roshni, on that case.
Thank you.
And we're happy for our clients, and congratulations to you guys. And then now let's talk about some quick updates before we get into today's topic. Of course, if you think that you know anybody who may be benefiting from our Facebook Lives, so please, go ahead and have them like and share our page and follow us on social media. If you wanted to go ahead and be subscribing to our newsletter as well, we send that out the first of the month, and of course, when there's any important updates. So some of the updates, for example, that we're going to start with today is the Supreme Court's decision on the notice to appear. So this just actually came out 1 o'clock today. If you want to Google the Supreme Court's decision on the notice to appear and what is actually considered a valid notice. And so for a lot of times, immigration enforcement would issue a notice to appear to an individual, but not provide a date and time, not provide the full charges. So the Supreme Court is kind of further strengthening this idea that everybody needs to be put on notice with the full charges. And actually, we even had conservative members of the Supreme Court join in on this decision. So I think this was a very important level of, constitutionality and due process. So for some clients, this is great news, and hopefully we can continue to provide them with more benefits. If you are one of our clients and you're in removal proceedings, there's no need to contact us. We will see how this may affect you and how benefit you, and make sure to add it to your case. Okay, and Roshni, do you have another one?
I do, yes. So USCIS has brought back the policy guidance on deference given to previous decisions. So there was a long-standing policy back in 2004 that if the USCIS officer was supposed to give deference, that is a consideration to prior determinations when adjudicating extension cases, extension requests, if the parties are the same and the facts are the same. But in 2017, that policy was rescinded. But according to under President Biden's executive order, that policy has been brought back now. So the USCIS officer will give deference to the prior determination as long as there are no material facts or material changes or new material facts to the case.
So this is actually really huge for so many clients. And for a lot of us immigration attorneys, we've been waiting for the Biden administration to give some relief with employment-based visas, for the investor visas, not just the situation or the crisis at the border. So, and we saw, unfortunately, too many times under the Trump administration where somebody had been here for L1 for 4 or 5 years without any issues. And then all of a sudden, at the final extension, they're asking us to prove eligibility, even though they've already approved the same case, 3 times before. So it was kind of absurd, and it was a hurdle to many immigrants and non-immigrants seeking extensions. So I know that we definitely welcome this news. That's great for people who are pursuing this, and hopefully gives more optimism for those who are considering E2s, L1s, H1Bs, and cases along those lines. So now let's just jump into our topic for today, unless you have anything else.
No.
Okay.
No.
All right. So we're going to get into our topic today. And by the way, for those, congratulations if you're halfway through Ramadan. I think we're on day 15. And Rashi and I are both vaccinated. So we are in compliance with CDC's new guidelines.
And I'm sorry, I'm drinking water. I have a sore throat, and I excuse me for my coughing fits if that happens at all.
All right. So today's topic is the writ of mandamus. Okay, and basically, before we jump into it, I want to just kind of clarify that for a lot of people, you may not qualify for this. If you are a refugee outside the United States, this is not going to apply to you. So these are for those individuals with processes pending with the US government. Many people don't understand, if you're a refugee outside the US, you're waiting for the IOM, which is a United Nations organization, and not necessarily going to help you pursue a writ of mandamus. So there's usually 2 different ways to get a mandamus lawsuit. Why don't you tell us about that?
Right. So this is a situation that occurs when you file a petition or something is pending with USCIS and you're waiting and waiting and waiting for the decision. And in that sense, clients sometimes comes to us and say, like, hey, what can we do to expedite this or speed up the process? Can we file a lawsuit? And the answer is usually yes, you can file a lawsuit. And there are 2 types of cause of actions. One is you can file either a mandamus, or you can file something called Administrative Procedure Act, that's called APA. And we are going to talk about the mandamus. What is a mandamus? How do you file it? And what you need to show for a successful mandamus case.
So mandamus, just to break it down, is, under the Mandamus Act, okay, which can be used to compel an administrative agency to act. Okay, so we need them to do their jobs. I've talked about writ of mandamus before, and it's a matter of forcing them to do their jobs. And this is actually not just limited, when the government has an obligation to provide a decision, right? You've gone through the steps, you've completed an application, now you're simply waiting for your decision. This is, a tool that we use. And this is not limited to immigration matters. So this is available, under, if you're in law school, or this is where agency law comes into play. And so this is compelling the United States to complete their obligation and the process.
Correct.
All righty. And where do you file, Rashni, these lawsuits?
Usually,
where are they done?
Usually district court has the subject matter jurisdiction, and what subject matter jurisdiction means that the court has the power to hear that type of case. So usually you will file with the district court. But an important thing to remember, Naif, with mandamus and the court is that the court has very limited power to deal with the mandamus cases. Yeah. In the sense that they can only compel the officer or the administrative agency to make a decision on this current delayed petition. They can't actually tell the officer or the agency that, hey, approve this case or deny this case. It's the officer's discretion.
There's ways to pursue a decision through the federal courts. We're not talking about that today. For arbitrary, capricious decisions, if we believe that it was invalid or they're inconsistent, that's not what we're discussing today. But Rashni is absolutely right. When you pray that the court help you get a decision, you better be ready to accept the decision to go either way. This does not guarantee that you're going to get an approval of a green card or an approved naturalization application. You're simply compelling them to take action, meaning to make a decision. So this is a conversation that somebody needs to have with their lawyer, right? So if the attorney came, or if the client came to our office and we didn't file the citizenship application, an attorney should do their due diligence and get the person's records completely. There might be something in the file that the client may have forgotten, or that is not told to us, or that's why it's so important to tell your attorney everything about your history, because before you spend thousands of dollars on attorney's fees and government fees to get a decision on a denial, maybe you were better off in limbo with a decision pending.
Correct.
Sometimes people are better off with just
Absolutely.
waiting for a decision. At least you can renew green card, work permits, or things like that. But so just be careful what you ask for. And that's just something to think about.
And I think that's why it's very important for you to have a consultation with a good attorney that, hey, do I have a merits to win this case, or even proceed with filing a mandamus?
Right. And if your case is not, ripe for a mandamus, or, how do we determine who's right? What are the elements for it? And what would you say some of the things that we look for when we're consulting with our clients?
Right. So mandamus, you have to prove 3 elements. And before I go into the elements, I just wanted to explain that there's a difference between elements and factors. So when you have to prove the elements, you have to prove all 3 of those. If there are 3 elements, you have to prove each of those. While if it's a factor, if you have to just prove like factors, then you can just prove 1 factor and you'll be fine with that. But with mandamus, the requirement is to prove all the 3 elements, which are the plaintiff has a clear right to the relief requested. The second one is the defendant has a clear duty to perform the act in question, and there is no other adequate remedy available to the plaintiff.
So let's break that down into plain English, okay? Plaintiff, that's you who is suing the U.S. government or agency. You have a right to the relief requested. So how are you tied to this application? So my grandma probably can't sue on my behalf if she's not involved with my process. But if I'm doing it for my spouse, for my wife, the application's in her name, I probably have a right for relief if I was the I-130 petitioner in this particular situation. The defendant has a clear duty to perform. So the defendant in this situation is going to be the U.S. government or the agency, and that they are the ones who need to defend themselves in this lawsuit that's been presented, and whether or not they had a duty to perform. So if you have a case pending with them, then that for me is going to be, and they have to issue a decision, they have a duty to perform on your particular matter. And finally, there's no other remedy available. So this is something that we're going to talk about. How do we prove that there's no other remedy available, or how do we know that the case is ripe to file a mandamus? We look at several factors or several things to determine if your case is good or ripe for a mandamus.
Correct. And I think with the remedy goes that if your case has been denied, and if you have a right to appeal, and you have to go through those administrative procedures that's been presented to you. You can't just go and file mandamus. You have to prove to the judge that, hey, I've been through all the steps necessary, and this is my last resort.
So sometimes if somebody comes to us and they have been waiting 2 years, but we need to make sure, have they followed the necessary steps? So for example, have they made inquiries with USCIS? Have they made ombudsman requests through USCIS? Have you reached out to your congressman or senator? This way, when it gets in front of a judge, they can see that you've literally tried everything. You've called, you emailed, you contacted your congressman has contacted USCIS, and you've had an independent agency do a review. So, that's what we want to make sure that, like, hey, there's no other way for you to get help in this situation because they haven't responded to anything. Do you agree to that?
Yeah, of course.
Okay. All right, so there's also situations with now the writ of mandamus is not typically the right language for when we're doing this type of action for a delayed naturalization case. There is a special section of the law that is dedicated for delayed naturalization applications, but it's similar, elements, similar things that we look at. So that's just a little nuance there, is whether or not a writ of mandamus or for a naturalization. Technically, you're filing a petition for a writ on a naturalization application, and it's not a writ of mandamus. So is this limited for immigration purposes? Is this limited to green card applications, to cases at Orlando or Tampa? Where else can we use this tool?
Well, we can use this tool, as you mentioned earlier, that we can file against public agencies. And we get this question asked a lot, that whether can I file a mandamus against consular processing, which is, like consular processing is delaying your case. You filed a petition, and your petition has been pending forever at the NVC stage. So the consular officers usually have an argument that, hey, the court in the U.S., they don't have power to hear the case against us, based on the grounds and called consular non-reviewability. I don't know, that it's just that word that's such tongue twister for me. Basically is that the Congress has given power to make visa decisions only to consular officers. But I think in present times and previously, the courts has already rejected this argument on the basis that, hey, no, consular officers also have a duty to perform.
Right.
They either have to issue visas or refuse them, but they have to act on it. They can't just sit on the visa petitions forever.
Yeah, we've actually done a case just like that in Morocco for two individuals. And to give you a picture of how it works, I would like to talk about where do we file, who gets served, what happens next. So typically, you have to find the proper jurisdiction for your case and select the proper district court. And then we have to think about who our defendants are going to be. Okay, the defendants can be somebody from the Department of Homeland Security, the head, or the Department of State. So in this case, like John Kerry, if your case is stuck at the consulate, then John Kerry, you'll be suing him in his capacity as in the Department of State. Okay, then you have to serve all these people, get subpoenas, and then that's how the lawsuit is officially filed, pay the filing fee, and demonstrate that service of process has been completed. Now, if you've ever sued somebody at a local level in Orlando for a business contract, typically they have 20 days to respond. At the federal level, for writs of mandamus, the government typically has 60 days to respond. So, Rajni, what do we want to see after we file this lawsuit?
After we file the lawsuit, we want to see is after we serve the complaint to the defendants, we want them to make a decision before even the case goes in front of the judge, so that this is what we were asking for. This is just to give them a notice that, hey, now the ball is in your court, and we should wait until we get the final decision on the petition itself. We don't want to voluntarily dismiss it. We just want to keep it going until we receive a decision from the government agency. So
the person representing the other side is, an assistant U.S. attorney. Okay, so we call them AUSAs. So they have a lot of work, right? They're doing drug trafficking, all these conspiracy, these frauds. So when they get assigned a lawsuit case simply because immigration hasn't acted in 2 or 3 years, we don't want the government to respond to our lawsuit. I know that sounds, counterintuitive, that you want your day in court and to win. Mm-hmm. No, we want them to see the file, think that, hey, this is absurd. What have we been doing all this time? They contact the local officer or, director at a USCIS office and say, we need a decision on this case. What's the holdup? And that's typically we get a response from them and typically saying, hey, a decision has been issued. Please file your voluntary dismissal that Roshni was talking about. And the voluntary dismissal is basically withdrawing your lawsuit. And then this going away and no longer being a headache. Now, if the government starts to respond to the complaint or there's affirmative defenses, that's not a good sign, right? That there's something in that file that we should have known about. There's something there that we're going to have to argue with about it. But I know it doesn't seem fair, but it's a great tool. Once we sue them, your file goes on top and somebody reviews it and they try to force a decision with it. So I like these. And when we tell our clients, let's sue the government, we usually get some crazy faces like, what do you mean? But it's your right in this country to pursue this type of action. And it's necessary in many cases, unfortunately. So, Rajni, is there a particular amount of time you think somebody should wait before filing this type of mandamus action?
Yeah, so we also get this question a lot as well, like how long should I wait before filing a mandamus case? And you can file that within 3 months of filing a petition. You have to wait till the processing time that's on the USCIS's website or the statutory guidelines, the deadlines. So for example, it could say that it can take up to 13 months or 60 days that, you should receive a decision. If this hasn't happened within 60 days, I would say wait 30 more days. It doesn't hurt waiting 30 more days or 1 more month.
Yeah, or especially after you've at least made enough inquiries. So because I'm sorry, you can't make online inquiries if your case is within processing times. So sometimes you have to wait that 2-year period, then send your inquiries, which Rashni's talking about, this 30 days for them to respond, and then probably some more steps.
Once it's out of the processing time and once you've done all the due diligence, then that's the time to file the mandamus. And there are situations, and there are certain situations where there are no processing times at all. The question becomes, when do I file, or when is the reasonable time to file the mandamus? And at that time, you have to show that the delay is very unreasonable. You have to show that there's no statutory guidelines, no processing times. However, this delay is very unreasonable.
Okay, so I don't know if we have any questions on this or any other topics that you wish to add on today's conversation.
Yeah, I just wanted to touch on the fact that you have to, like, have you touched that before as well, that you have to know that you have good merits in the case, because at the end of the day, you don't want to file the mandamus. If you file the mandamus, then you have to be ready for a decision that it may not be in your favor, that your petition may get rejected, right, plus the court costs,
right?
So plus the attorney's fees.
If you filed this case 3 years ago, your marriage was doing well. Now you're separated from your spouse. Might not be the best time to file a mandamus if immigration was to question the validity of the marriage, right? Then there might be some issues happening there. So, we just say that keep those things in mind when you are considering this. Now, I do want to talk really quick about just COVID and the delays and how that changes things. So just like USCIS is understaffed sometimes, or some people are out either getting vaccines or are out sick, this causes delays, right? Even in our office, we had people out the last 2 or 3 weeks, and they could be because of vaccines or whatever the reason is. And sometimes things are out of our control as far as processing times. So this same argument or this same reasoning can be used by the consular process. So if you are in Morocco, if you are in India waiting for your interview, and this kind of delay happened after the pandemic, the judges might understand the government's argument or consideration as to why this is stuck here. Why is this delayed? So we have to keep that in mind as well. And I just wanted to share that with you guys tonight. So. Do we have, what are the average government fees, filing fees? Do you know?
No, I don't know in my head.
It can cost several $100,000s for the filing fees, because you then have to serve the parties. And so that's something to consider. There's lots of fees involved with these processes.
You have to get summons, and you have to serve them with the
Mhm.
process server as well. So yeah, that adds up.
So that's what our live was on today. We are, getting admitted to different districts to pursue more and more of these actions, which I do starting to enjoy greatly. And I hope that, first of all, you don't have to go this route. I hope that the agencies do their jobs and you're not forced to spend more money to get a decision that you're entitled to. So I will not be here next week for Facebook Live. There's either going to be a break or a guest host. So if you have questions for us for the next Facebook Live, we will address those next time. And by the time the next third Thursday happens, Ramadan will be over, and we will have Miss Besma Alawi back to do the live in Arabic. And we will go ahead and then answer your questions as we always do. As always, please feel free to like and subscribe to us on all social medias. And if you like this video, please share it with your friends or family. And I want to thank Roshni for staying late and doing this live with us today.
No, thank you so much for inviting me.
And we'll see you guys around. If you have any questions, feel free to contact us through our website or on the office phone number. And we do speak English, Spanish, Portuguese, Urdu, and Arabic.
And Hindi.
And Hindi in our office. So, all right. You have a wonderful day.
Bye-bye.